At 7:03 a.m. on November 14th, I watched Denise Harrow strike the match. She was standing in her stone outdoor fireplace, wrapped in a cream cardigan that probably cost more than my chainsaw. 2 of my logs were already stacked inside her fire pit. I knew because I had carved a shallow crescent mark into the bark at exactly 3 inches from the base. The moment the flame caught, the log didn't burn. It erupted. Not fire, color. A bright cloud of neon pink powder burst upward like a festival cannon, coating Denise's patio furniture, her cardigan, and the decorative HOA-approved stonework she'd fined 3 neighbors over. She screamed. Her husband jumped back. And at exactly 7:03 and 42 seconds a.m., my security camera captured everything in 4K resolution with embedded GPS metadata. She had no idea she'd just ignited Exhibit 9. My name is Daniel Mercer. I'm 42 years old, a structural engineer by trade. I don't yell. I measure twice, document 3 times, and respond once. In May 2023, I bought a 2-acre forest lot at 1187 Cedar Ridge Road. It's technically considered rural residential. The Pine Hollow Estates HOA boundary ends 312 feet south of my driveway entrance. That's not an estimate. That's the distance on the county GIS parcel overlay, map sheet 14C. Before closing, I requested a covenant status letter from Pine Hollow Estates. Dated April 17, 2023. Signed by then-President Mark Alvarez. It stated clearly, parcel ID 09-47-1187 is not subject to Pine Hollow Estate CC and RS. I framed it. The first red flag appeared in September. I came home to find a laminated orange notice zip-tied to my wood rack. Unapproved storage materials. Remove within 7 days or HOA action will commence. It was signed, Denise Harrow, Acting Compliance Chair. I called the number listed. I'm not in your HOA, I said calmly. Yes you are, she replied. All properties on Cedar Ridge fall under aesthetic governance. That's not how property law works. She hung up. That night, I installed 2 additional cameras covering my woodpile. Ring Model X3, firmware version 9.12. Timestamp sync via NTP server. 3 days later, 5 logs were gone. That was evidence rung 1. Rung 1, missing wood. Proof, camera footage at 6:42 a.m., September 19th. Denise loading split oak into a silver Lexus RX 350, plate PHX 6621. Why it matters, establishes pattern of unauthorized removal. Rung 2, I filed incident report 23-0919 with the county sheriff. Not for theft prosecution, yet, but to create an official timestamped record. Rung 3, I sent certified mail, tracking number 70210950000188432197, to Pine Hollow HOA requesting written confirmation of jurisdiction. They never responded. Rung 4, Denise emailed me a fine notice for $350. Header displayed Pine Hollow logo. Footer listed a P.O. box that didn't match the HOA's registered address on file with the Secretary of State. Rung 5, I pulled Pine Hollow's annual filing. Denise was not listed as a board member. Her titled Acting Compliance Chair did not exist in Bylaws version 2018 revision. I didn't confront her again. I let her escalate. The vendor intimidation started in October. I had scheduled a cord delivery from Miller Timber Company. Invoice #MT 7713. Paid $1,240 for seasoned red oak. At 9:18 a.m., the driver called me. Hey, man, there's a lady here saying your property is under dispute and we can't deliver. I walked outside. Denise stood in front of the truck holding a clipboard. This delivery violates HOA storage guidelines. It's my land. It's visually disruptive. I filmed the interaction on my phone. Rung 6, vendor interference on private property. Legally relevant because it establishes tortious interference with business relations. The driver delivered anyway after I showed him my deed. The next escalation was paper. On October 12, I received a notice of intent to lien. Amount due, $1,750 in accumulated fines. It listed a case reference, PHCC 1024. I looked up the county recorder's office. No such filing existed. Rung 7, fraudulent lien threat. I requested verification from the recorder's office. Clerk emailed confirmation, no instrument filed under parcel ID 09-for47-1187. Saved as PDF with metadata intact. Then came trespass. October 28, 2:11 p.m. I got a motion alert. Denise and a landscaping crew were on my property. They were dismantling my wood rack. I stepped outside. I said evenly, "You are currently trespassing." She waved a document at me. HOA Remediation Authority. I didn't argue. I called the sheriff. Deputy Collins arrived at 2:34 p.m. I handed him my deed and the covenant status letter. He turned to Denise. "This property isn't in your HOA." She insisted it was under review. Deputy Collins issued her a verbal trespass warning. Incident supplement filed under Report 23-0919A. Rung 8, Law Enforcement Confirmation of Non-Jurisdiction. That should have ended it. It didn't. 2 weeks later, a certified envelope arrived from a law firm, Harrow and Pike Community Council. Inside was a photocopy of my supposed HOA membership agreement. My name was signed at the bottom. The signature wasn't mine. Rung 9, forged membership document. But here's where it got interesting. The notary stamp listed commission number 7783412. I searched the state notary database. Commission expired April 2023. The document was dated June 2023. That's not a small mistake. That's a felony-level mistake. I didn't confront her. I forwarded everything to attorney Melissa Grant, property litigation specialist. Retainer paid November 3, $5,000. Meanwhile, Denise escalated publicly. She posted in the Pine Hollow Facebook group that I was stockpiling hazardous materials. Someone called the fire marshal. Inspection occurred November 8. Marshal Reyes walked my property. Standard firewood stack. Proper clearance. Nothing hazardous. He handed me inspection clearance form FM 1108. Rung 10, official clearance document disproving hazard claim. Then she made her biggest mistake. On November 10, Melissa obtained a copy of Pine Hollow's internal board emails through a cooperative board member. One email from Denise dated October 5 read, "I know technically he's outside the boundary, but if we enforce hard enough he'll fold." Attached was a draft of the forged membership agreement. Metadata showed the document was created on Denise's personal laptop, user profiles D. Harrow. Creation timestamp, October 3, 11:14 p.m. The notary listed had not renewed her commission. Melissa's exact words, "This is fraud and attempted wrongful lien." We filed for temporary restraining order under Case No. CV 24-1187 in County Superior Court on November 12. Simultaneously, we submitted a complaint to the State Notary Division and the District Attorney's Economic Crimes Unit. But I still needed something undeniable. Which brings us back to the logs. The gunpowder's in the title? It wasn't explosive powder. It was commercially legal colored smoke composition used for photography reveals. I purchased it from a licensed supplier. Invoice #SP 4419. Non-explosive classification under ATF guidelines. I hollowed 2 logs and sealed the powder in thin paper chambers that would burst into dye when exposed to flame. Completely legal. Completely harmless. And completely incriminating. At 9:17 a.m. on November 16, sheriff's deputies and a county civil inspector arrived at Denise's home. I was present because I had been subpoenaed for the TRO hearing scheduled that morning. Denise stood on her driveway, pink residue still visible in the grout lines of her patio. Judge Ellison reviewed the file. KCV 24-1187. Mr. Mercer alleges fraud, trespass, and attempted wrongful lien. Melissa presented the forged document. Judge Ellison looked at Denise. Your notary's commission expired prior to execution. Do you have evidence this property falls within your HOA? Denise shuffled papers. None matched the county GIS overlay we submitted. Deputy Collins spoke clearly. We previously confirmed the parcel lies outside Pine Hollow jurisdiction. Judge Ellison issued an immediate temporary restraining order prohibiting Denise or Pine Hollow representatives from entering or contacting me regarding property enforcement. He also referred the forged lien threat to the district attorney for review. Denise's attorney attempted to argue aesthetic impact. The judge cut him off. You cannot regulate land you do not govern. Hearing concluded in under 22 minutes. Within 3 weeks, Pine Hollow's actual board voted to remove Denise from any committee position. Their insurance carrier contacted Melissa regarding potential liability exposure. Settlement negotiations began. Terms finalized January 8. Denise agreed to pay $8,750 in attorney fees. Issue written retraction to HOA members. Record affidavit acknowledging my parcel lies outside association boundaries. Cover costs of wood replacement and rack damage totaling $2,340. Cease all contact. The fraudulent lien complaint was formally withdrawn. The Notary Division issued a suspension to the notary involved pending investigation. No dramatic arrests. No handcuffs. Just paperwork. Clean paperwork. This morning, I stacked a new cord of oak beside my cabin. No notices zip-tied to it. No SUVs idling at dawn. Just wind through pine branches and the crackle of a legitimate fire inside my own stove. I poured coffee into a metal mug and watched sunlight hit the exact boundary line marked on the survey stakes. 312 feet. That distance cost Denise nearly $10,000 and her reputation. I didn't beat her by yelling. I didn't beat her by confronting her in the street. I beat her with timestamps, certified mail receipts, metadata, inspection reports, and one very colorful log. Because here's the truth. You don't beat a Karen by arguing. You beat her with clean records. And sometimes, a little pink smoke.